1 CACV 19-0716 Shea versus Blount. You'll notice that Gotani is not here with us at the moment. He had an unavoidable conflict. He did participate in conference today, and he will review the recording of the argument. So he will be participating. So each side will have 20 minutes to present their argument. Appellant, you may reserve any amount of time that you want for rebuttal, but you'll have to keep track of that yourself. We do have a small clock in the lower right corner to help guide you, but you're in charge of managing your time. We are recording this argument, so when you speak at the podium, please identify yourself and your client so that we can keep everything straight. The argument will be up on YouTube in a couple of days if you wish to review how you did. We've read the briefs, we've covered the case, we're familiar with the issues and the law. So when you begin your argument, just start right out with what you would like for us to know. Counsel, you may begin.
Thank you, Judge Howe. Good morning. May it please the court. My name is David Lunn, L-U-N. I represent Shea Conley Development, LLC. And as this court knows, Shea Conley Development, LLC had the right to have its dispute with Blount Contracting heard by a jury. Shea Conley Development also had the right under Arizona law to have its case presented to a jury free of prejudice to Shea Conley Development. In this matter, Shea Conley suffered severe prejudice as the direct result of 2 jury instructions that the trial court gave to the jury despite Shea Conley's well-founded objections to the jury instructions. The first of those jury instructions relate to Blount's argument that Shea Conley's claims were barred by accord and satisfaction. The second jury instruction related to Blount's unfounded claim that because Shea Conley was the first party to breach the contract, Blount's performance was excused. Well, in this matter, the trial judge had at least 3 opportunities to keep those jury instructions from the jury. The accord and satisfaction defense was objected through a motion in limine prior to trial, which was denied by the judge. At the close of both Shea Conley's case and Blount Contracting's case, Shea Conley moved for directed verdict on liability and on both accord of satisfaction and the excused performance defenses. Each of those motions were denied by the trial court. When the
Counsel, I understand that you're pressing those arguments, but could you begin by talking about the better material argument and how that affects this case?
The material, the Shea's material breach, Your Honor, or
yes.
The material breach that Blount claims happened was when Shea Conley came in October and told Blount Contracting, after agreeing to a change order prior to Blount Contracting even starting work, at the beginning of the project, Blount Contracting gave Shea Conley a schedule. Blount Contracting keep falling behind the schedule. So as a result, in October 2016, Shea Conley representatives met with Blount Contracting representatives on site and told Blount Contracting that they were going to have to hire another contractor to finish the east side of the project because Blount Contracting was so behind schedule. Blount Contracting, at the time that those representations were made on October 10th, 2016, voiced no objection to Shea Conley that Shea Conley was going to reduce Blount Contracting scope of work. In fact, on October 11th, 2016, Blount Contracting sent an email to Shea Conley confirming its promise to complete the west section of the project by October 21, 2016. So at the time on October 10, 2016, when Shea Conley said we're going to reduce your scope of work, that was the time for Blount Contracting to say, you can't do that, you'll be in breach of contract. Instead, what Blount Contracting did, it reaffirmed it was going to complete its entire scope of work as related to the west side of the project. And that was the following day. Blount did not send Shea Conley a notice that Shea Conley was breach of contract. Blount said we're going to complete its scope of work on the west side of the project. Now, to the extent that Shea Conley may have breached his contract when he reduced Blount's scope of work, Blount waived that breach, at least as it related to the west side of the project, because it renewed its promise to complete that scope of work by October 21, 2016.
Well, okay, so, and doesn't that depend on whether Blount left better material? Isn't that the dispute, whether the material left behind was better material or not better material?
Yes, sir, that's absolutely correct. Because Randy Blount, the owner of Blount Contracting, testified that Blount did in fact complete their scope of work on the west side of the project, and then they left. At trial, Randy Blount testified that he did not know what better material meant. The two parties who negotiated this change order were Steve Shea, who was on site every day of the project, and Bud Blattner, Blount's representative. And although Bud Blattner was listed on the joint pretrial statement as being a witness, he didn't testify at trial. So the only person who testified at trial regarding the meaning of what better material was Steve Shea. And of course, as the court knows, when interpreting contracts, you try not to construe a contract in a way that renders another term meaningless, and in specific terms, control over the more general terms. Randy Blount testified at trial that Blount Contracting made no attempt to distinguish between what type of dirt it left on the pad adjacent to the side of the project.
Was better material defined in the contract or in the change order?
It was not a defined term in the contract. It was a negotiated term between two parties, one who testified and one didn't. And the Blount contends it must have been that the jury didn't believe Steve Shea's interpretation of what better material meant. The point here, Your Honor, is that Randy Blount, who testified, said Blount Contracting made no effort to distinguish between what material it left. It simply pushed boulders and cobbles and caliche on the other side of the project without trying to distinguish between what type of material it left.
But weren't they allowed to leave some of that caliche? Wasn't there a side agreement that they could leave some of that for your client, and that your client was going to have to figure out, I think it said, figure out what we're going to do with this material? But that wasn't Blount's responsibility at that point, was it?
Well, we would disagree with that, Your Honor, based upon Steve Shea's testimony. Steve Shea, at the point when Blount Contracting was working on this project, they were so far behind schedule that Shea Conley, in order to get the pad clear and ready for development, agreed to allow Shea Conley or Blount Contracting to push the boulders over to Blount. And that's what Steve testified about at trial. There was no other person at trial who was actually on the project all the time. Neither of Blount's witnesses, they were on the project one or two times at best, each of them. So Steve Shea.
I was just trying to get to the bottom of your comment that Blount testified that they gave no regard to what materials they put where, but they had an agreement for better materials, and they had an agreement for the excess caliche both to be left on the property, correct?
There was an agreement that was sent to allow Blount Contracting to leave some of the bigger chunks on the other pad to be able to clear the site for construction, is what they testified. They also were, if they were going to leave anything else on that site, it was to be better material as set forth in the change order. And it's really to consider this is that if Shea Conley didn't, what type of dirt that they were willing to accept on their site, they wouldn't have included the term better material into the contract. Better material did have a defined term. Better material was not simply all the same type of dirt they were digging up and putting on the site. And I acknowledge, Judge Bailey, that there was the email talking about there was an agreement to move some larger chunks to the site. And that's just a small fraction of the amount of dirt that was left behind by Blount. And we're really complaining about the issues of all the other dirt they left behind, but no effort to distinguish between the material. And again,
Counsel, I thought Blount and Shea both testified that the dirt would need to be screened or crushed, and that's what made the material, made the excess dirt better material that had been done on another part of the project. So as I understand it, Mr. Blount understood that that material would be screened and crushed, and then that would make it better material.
he did testify that they were going to screen and crush the material, and that's the material they actually hauled off site. They took that, the material that they crushed and screened would have been the material that Shea Conley would have loved to have had, because they could have used that. It's called ABC, aggregate court base, which they could put on the surface before they paved. The problem is that the material that Blount crushed and screened, they actually loaded that on dump trucks and hauled it off the site. And that's an undisputed fact. What Blount did is they took the dirt from the site that they did not screen, that they did not crush, and they simply pushed that onto the site adjacent to the west side's pad. And had Blount actually crushed and screened and left that for Shea Conley, that would have been the better material to
But
use.
they were required under the contract to be the ones to crush or screen.
I 100% agree with that, Judge Bailey. What the intent was is if there was better material that was there, that Shea Conley would accept it. You know, and Dykstra on the other side, when they took over the work, they found a lot of the aggregate course-based material and left it behind to be used on the project, and Shea Conley did not have to process it. And there was no benefit to Shea Conley at all just to take material that could not be used on the project. There's no reason for Shea Conley to assume that duty to haul off dirt that's not usable, that was under Blount's contracting to haul off.
I guess I'm just wondering how the jury distinguishes between all of that, and that you say better material, everyone agrees, has to be screened and crushed. There was no obligation by Blount to do any screening or crushing, but then there's the complaint that they weren't leaving better material at the site. But it sounds circular, like they couldn't. They weren't under any obligation to do the extra work that it would take to provide your client with better material. So where does that leave a jury in figuring out how all that plays together, and why would we overturn their determination regarding that?
Well, as Steve Shea testified, and even Bart Shea testified, Shea Conley didn't want any dirt. They hired Blount Contracting to do all the excavation, the grading excavation of all the excess dirt. That was the original contract. They didn't want any of the leftover dirt. What Shea Conley was doing, according to the testimony of Bart Shea and Steve Shea, was trying to get Blount to move quicker to get the pad clear, because they had all these other sub-trades from underground retention, electrical and plumbing lined up to come start doing the work on the project based upon the schedule Blount gave them. So All they were trying to do is agree that you won't have to haul this away. If you find better material, leave it. You don't have to haul it away. We're going to try to help you finish this job. And that was the testimony that was given at trial. And that's how the jury could understand that issue, Your Honor. They didn't want dirt. Shea Conley did not want dirt. If Blount was able to find some better material as they were excavating the west section of the project, Shea Conley said, we'll help you out so you don't have to spend the money and time getting rid of it, and we'll take that because we can use it. That was the distinction that was testified at length in trial. And I wanted, if there's no more questions on that.
Thank you.
I would like to briefly address the accord and satisfaction argument. I think when the court would review the timeline set forth in the reply, it's dispositive of the issue on its face. On October 26, 2016, Blount submits his final pay application asking for $164,729, saying this is the amount you owe us for our work. This is the amount you owe us so we can pay our suppliers. That's all encompassing of the amount that Blount Contracting said it was owed. On October 27th, Shea Conley put Blount in default. And there were negotiations that went back between the parties between those times. And then finally, December 1st, 2016, Shea Conley agrees to pay Blount $162,729 if it cured its default by removing the remaining dirt, and $122,500 if it did not. Blount didn't accept that offer, so on 7 days later, on December 8th, Shea Conley advised Blount it was going to pay its supplier Empire $40,387 to resolve its lien rights. And then Shea Conley asked Blount to remediate its dispute. On January 3rd, instead of agreeing to mediate, Blount filed a mechanics lien for $118,000. Shea Conley, after it was told his construction funding was going to be pulled, filed a complaint and then agreed to pay that lien. Now, for Blount's accord and satisfaction claim to have any merit whatsoever, Blount would have had to agree to accept $82,113 to resolve that claim. Why is that? Well, because Blount submitted the pay application asking for $162,729, and that was to pay itself and its supplier. Shea Conley agreed to pay $122,500. So after they did that, the remaining balance, if Blount were to accept that offer, which it did not, it would have been $82,113. So the accord and satisfaction was saying you would take this $120,500 to compensate yourself and pay your supplier. Blount did not do that, so Shea Conley paid directly. There's simply no merit to the accord and satisfaction argument. The trial judge said there's thin evidence, but there's none. The accord and satisfaction defense is not even a close call. The jury instruction severely prejudiced Shea Conley when the court gave that instruction. And briefly, I'll address the directed verdict on liability. And the court should never have given the two jury instructions. There was the undisputed facts supported Shea Conley's position. The contract said that Blount Contracting was to remove and excavate the material. There was a change order where Blount was going to be paid some extra. Shea Conley agreed to take better material if they find it to help them with the project, but they weren't going to take material that was garbage. Randy Blount testified all that Blount did is move dirt over to the other side. They failed to remove material that was not better material.
Well, counsel, but isn't the issue of what is better material or not, which could have been left behind, it was not defined in the contract. It was up to the jury to figure out what better material was, correct?
I agree with that, Judge Howe. But if they accept Ronnie's Blount testimony that all they did is push up the caliche boulders and rocks and cobbles and just dug up material and stuck it in their site, there was no effort for them to distinguish between what was on site and what was better material. If that were the meaning, it would render that meaning useless in the contract. There was a decision by the parties to include better materials, so they could have easily said, just dig up the dirt and put it on our side of the lot. The contract didn't say that. The change order did not say that, Your Honor. At this time, I'd like to reserve the remaining time I have for rebuttal.
Thank you, counsel.
Thank you, Your Honor.
Good morning, Your Honor. My name is Jim Armstrong, and I represent the appellee in this Blunt Contracting. My main point here is that there were 5 reasons, 5 options the jury had to decide the way they did. Any one of those 5 reasons were sufficient to render a verdict in favor of Blunt. First one, we argued there was no breach of contract. Blunt complied with the change order, which was the result of an erroneous soils report that misled them over the type of soil that they would be excavating. The change order was entered into. The change order permitted hauling off, I think, 1,100 loads at $42 a load, and that was an extra amount from the original contract because of the difficulty caused by the soil conditions. They actually did haul off 749 loads. They were also to supply a dump truck to SCD to allow them to move, I think it was 700 loads of material to another site on the project, to a different pad. They left that stockpile under the terms of the change order, and as Judge Bailey stated, what you referred to as a side agreement. That side agreement is at tab L of our appendix, and it was an email from Steve Shea stating, as for the larger caliche chunks, that's the real problematic dirt that was being excavated, stockpiling in the vacant lot to the south of Building C is permissible. We will have to look into the best way to utilize or dispose of them. So we had an agreement. We had an agreement that modified the change order that allowed the stockpiling of those materials. In addition,
So does that mean that the breach didn't depend on whether the material left behind was better material or not?
That's our position, Your Honor. You're correct. And on the better material issue, better material was not defined in the change order. The only testimony the jury heard was from Steve Shea, who attempted to define better material. But as we note in our brief, the jury doesn't have to accept his testimony. He's an interested party. There was plenty of other evidence to indicate that the Shea witnesses were less than credible. One of which was this 6-week delay in actually alleging a stockpile as a grounds for the breach. Their attorney sent an initial demand letter raising 3 completely different grounds, one of which was that you fell behind schedule. And the other main one was that you're selling dirt without telling us, and that's a breach of the contract. We need an accounting of the dirt that you're selling on the side. No mention at all about this stockpile that was left on the side. It wasn't until 6 weeks later, after an exchange of multiple emails between the attorneys, that they first raised this issue. Again, the jury's entitled to draw an inference from that this breach claim was made up. And that gets me back to my starting point about the jury having 5 options. First one, no breach of contract. Second one is, under the contract, if there had been a breach, SCD was required to give notice and an opportunity to cure. If they believe that this stockpile, leaving it there with what they didn't consider to be better material, if that was a breach, they were obligated to give a written notice and allow my client to cure the breach. And there's testimony that they said, we could have done that. We could have cured the breach. In fact, we could have finished the other side of the project much faster than the contractor that was brought in by SCD without our client's knowledge. So that's the second ground. There's no breach because there was no notice and opportunity given. Then we have 3 affirmative defenses. That includes the accord and satisfaction argument, the first prior breach. There's actually 2 prior material breaches. The first one was hiring Dykstra to do the work on the east side of the project. SCD argues that that was not a material breach. Well, the materiality of a breach is a jury question. The jury received a accurate instruction on that. There was no objection to the language of the instruction, which appears in tab X of our appendix. The other point on that, on the hiring the new contractor, Mr. Lund raises again today that we didn't object. We didn't immediately cease work, declare a breach, and walk off the job. The reason we didn't do that is we were kind of misled. We asked, we come to this meeting on October 10th in the trailer on the site. We see another contractor there. We ask what the heck is going on here. They refuse to talk to us. And there's much testimony about that. There's even, I think, a couple of emails where we attempted to find out what's going on here, and the response we got from SCD was finish up on the west side, and then we'll discuss how this impacts the contract. So we were being pushed off to actually declare a breach. The other thing is, yes, we finished the west side of the project. We did that, and there's testimony on why we did that. We wanted to make a nice, clean claim. We wanted to leave no doubt about the work that we did. Instead of walking off in the middle of finishing that side, we wanted to finish it up and have a nice, clean payment demand. So there was no waiver there by the fact that we didn't immediately object, and we did, in fact, finish the work. And on the waiver issue, which they've argued, that issue itself was waived. Waiver was never argued in the motion for new trial, and that's what this appeal is from. It's from the motion for new trial. It's not from the judgment itself. The motion for new trial did not argue waiver, that we waived the prior breach affirmative defense by not walking off the job and declaring a breach. So we would argue that issue's been waived. The fourth ground that the jury had to find in favor of our clients was a second prior breach. That occurred when SCD demanded that Blunt remove the stockpile without any compensation. We had a contract dealing with that. The change order itself said if SCD wants Blunt to remove more stockpile, it can do so. It can give written notice, and you have to pay us, I think it was $45 per load. So they had an option of doing that. They had a right to do that, and instead they insisted on my client performing that job, hauling off the dirt without any payment at all. That's a breach of contract. The fifth reason is the accord and satisfaction. The main argument that's been made is SCD gave up nothing. They didn't receive a benefit from the accord and satisfaction that we argued occurred when the mechanics lien was resolved. And that's simply not true. Our client had claims more than just for the work it had done on the west side. It had claims for lost profit on the east side portion of the contract. They also had claims for overhead. They also had claims for attorney's fees. So all three of those items were given up and benefited SCD as part of the resolution of the mechanics lien issue. Our client believed, they testified, they believed they were settling everything, and unbeknownst to them, SCD had already filed suit, this lawsuit, against them during the negotiations and the resolution of mechanics lien. And there's testimony there that they never would have settled this if they knew that Lund did not share their belief that they were settling everything as a result of the mechanics lien. The other point on the accord and satisfaction is this was the object of a motion in limine. The trial judge, gave his reasoning for denying the motion on the record during a hearing. That's the only place it is, and the appellants did not order the transcript of that hearing. And I think under established appellate law, if a necessary transcript is not ordered, this court, the Court of Appeals, must assume that the missing transcript would have supported the trial judge's ruling. I guess the overall point is this was a trial. This was a case that had 5 days of testimony, had dozens of exhibits. Absolutely, there was conflicting evidence. Even prior to trial, STD tried to win on summary judgment. The trial court found, no, there's disputed issues of fact. And there were. The jury had the right to resolve those issues of fact. The judge on the motion for new trial has a very strong abuse of discretion standard in his favor. And his ability to order or deny a new trial is also very much limited by the discretion that must be given to the jury in resolving these issues. And we would contend that there is no basis for overturning these issues on review, given the strong standards of review that apply. I mean, I can look at my notes on your questions that you had asked. Yes, you were talking about whether the material had to be crushed at one point to be able to be removed. Yes, we're not arguing that was a breach. I mean, yes, it was our responsibility to do that. It made it more expensive, and that's why we had the $45 charge per load that was added in the change order. That made the contract more expensive, and we reflecting the situation that we did have to crush that material. In fact, there was testimony that we actually lost $29 per load because of the added expense of having it.
Well, counsel, I asked that question in view of how the material was defined, or at least as I read the record. I understand that Mr. Blunt's view was that because the material we left behind would need to be crushed and screened, we thought it was better material. Is that correct?
I don't believe that. No, I don't believe that's was the testimony, Your Honor. The material that we crushed and screened, we actually removed. We did take it off the project. What we're relying upon is the side agreement in the email saying, yes, you can leave caliche in the stockpile, and we'll figure it out later.
Okay.
They never did, you know. So
thank you, counsel.
Thank you, Your Honor. Any further questions?
No, thank you.
Thank you.
Mr. Gunn?
Thank you, Your Honor. I think that when the court looks at exhibits 8 and 8 at page 1163, see that there's far more than caliche left there. We're talking about all the soils that were pushed over to the site. And to remind the court, when Blount Contracting entered this contract, they agreed to remove all the dirt they excavated. As an accommodation, they entered a change order. They're allowed to leave better material if there was any. And of course, there wasn't, as shown by the testimony and through the exhibits. It's interesting that Blount claims that Shea Colley did not give Blount an opportunity to cure his defect. On December 1st, 2016, through trial exhibit 10, Shea Conley agreed to pay Blount $162,729 if it cures its default by removing the dirt, and $122,500 if it did not. Not only did Shea Conley agree to make a demand for them to cure, which they failed to do, they also agreed to pay him more money if they did cure. They never said they would not pay the contract price to cure. They said you need to cure your default. The counsel talked about that there were 5 different reasons the jury could have found on this, and while that may or may not be true, what we know is that the jury instructions given by the court cannot prejudice a party. The jury instructions on excused performance and accordant satisfaction severely prejudice Shea Conley. For those reasons, we request this court to, 1, find a directed verdict on behalf of Shea Conley, or 2, reverse this trial because of the severe prejudice caused to Shea Conley Development, LLC.
Thank you, counsel.
Thank you.
We appreciate both of your arguments today. We'll take this matter under advisement. I'm sure Judge Catania will review the argument and will issue a decision in due course. Thank you very much. We stand adjourned.